case that come before the court is State versus Cunningham, and both sides will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes if they so choose. And when the attorneys are ready, the court is ready to proceed.
May it please the court, opposing counsel. My name is Attorney Joseph Salzgeber on behalf of the appellant, Seth Cunningham. We raised two issues, both suppression issues, before this court. Back on Sunday night going into Monday morning of May 13th, 2013, there was a robbery at the Twilight Boutique at the corner of Pearl Road, Route 42, and Laurel Street in Brunswick, which is a small plaza there. Officer Gagliardi of the Brunswick Police responded to a dispatch from the Brunswick Police Department to that location, and the dispatcher indicated that there had been a robbery, and the following description was that of the suspect: a male wearing a ski mask and camouflage jacket, approximately 5'8" tall, skinny build, with a black gun, who had fled on foot heading eastbound on Laurel Road. They stolen a water bong from the Twilight Boutique. The Twilight Boutique is what is referred to as a head shop. They sell paraphernalia type of items that could be used for smoking tobacco or illegal substances. Officer Gagliardi responded to the scene. It was approximately 12:17 a.m. Sunday night going into Monday morning. He drove around the building, then he drove into the nearby neighborhoods around 3 cul-de-sacs. Approximately 5 minutes after he arrived at the scene, he passed a vehicle, a black 2010 Dodge pickup truck driven by my client. He observed no traffic violations committed by that vehicle as he passed it on Clemson Road, which is a side street approximately a quarter mile away off of Laurel Road from the scene of the robbery. He observed that vehicle pull into a driveway at 1748 Clemson Road, which is condo-style homes, and he turned around, ran the plate of the vehicle, found out that that vehicle was owned by my client who lived in nearby Medina, that he was a male, but that was the only aspect of the description that fit. There were no warrants, active warrants out for the client, no warrants whatsoever actually, no arrest record at all. Nonetheless, my client was parked in the driveway. The officer blocked him in with his own vehicle, exited his vehicle, and approached my client's vehicle with his gun drawn. At first he didn't see anyone in the vehicle due to the tinted windows on the side, so he proceeded towards the front of the vehicle, saw my client leaning back in a resting position in the vehicle, the driver's seat of the vehicle, and pointed his firearm at my client, then went to the side door, the driver's side door, opened the vehicle, ordered him out of the vehicle. It was at that time that he observed a camouflage jacket, a mask, ski mask, and the bong in the back seat. He asked my client, without giving him any Miranda rights, if he had robbed the store across the street. He indicated that he had, actually he asked him about it, if he had anything illegal in the car. He said that he had a bong in the vehicle, and then he asked him if he had stolen it from across the street. My client replied yes. Subsequently, after obtaining this confession, without the benefit of Miranda rights, he subsequently did Mirandize my client in the back of the vehicle, got a more elaborate admission. My client was subsequently taken to the Brunswick Police Station, where he was Mirandized again by Officer Puhak and gave yet another confession. It's our contention that there are two violations of the Constitution involved in this case. One is the unlawful seizure of my client and search of a vehicle. That's assignment of error number one. It's our argument that the trial court committed a reversible error in denying Mr. Cunningham's motion to suppress all of the evidence obtained by Brunswick police based on the warrantless seizure and arrest of Mr. Cunningham at gunpoint. In this particular case, they observed no traffic violations. So this really wasn't a traffic stop situation. This was a situation where the officer was entitled to stop his vehicle and approach my client's vehicle. However, he did so with gun drawn and went into my client's vehicle without ever tapping on the window to see if my client was in distress, as was one of the assertions made by the state at suppression. He just pointed the gun at him, ordered him out of the vehicle, opened the door.
What are we to do with the officer's observation that when he saw the truck, it seemed as if the truck was taking, these are not his words, evasive maneuvers to try to turn quickly into the driveway and then go up to the house and then back away?
I think, Your Honor, that the officer made some statements that were not accurate in that sense. We attacked the competent, credible evidence on 3 grounds of what the court found. I think he indicated that the vehicle turned into the driveway. He characterized that as somehow being suddenly turning into a driveway. That is true. However, he indicated that he had been familiar with that residence because he wanted to buy it approximately 5 months earlier when it was up for sale. However, he had been familiar with the vehicles that used to park there, and he was not accurate in describing the vehicles that were associated with that residence at suppression hearing. He indicated he had no explanation for a maroon-colored vehicle that was parked in the driveway as well. He indicated there were 2 other vehicles that he was aware of that parked there. He could not name any of the vehicles associated with the neighboring residences. So we believe that that was at least exaggerated on the officer's part. He indicated he knew the truck was not associated with that house, but that was not accurate because he never testified specifically concerning which vehicles were associated with the house. He could not identify the make and models of the vehicle. He only knew about the 2 silver-colored SUVs and a white truck he had seen there at some time in the past. It's our position that based solely on the fact that what he knew was that there was a male who owned the vehicle and was presumed to be the driver of the vehicle, that was the sole basis for the seizure. And in this case, I think that the law indicates quite clearly that if you point a gun at someone and order them out of a vehicle, that they are seized for all practical purposes.
Well, before we get to that point, the officer also indicated that as he approached the vehicle, the windows were heavily tinted. We don't know whether, well, the windows were heavily tinted, so he couldn't see inside, but that he did see the male subjects, I think his words were slouched down or leaning back. It seems as if the trial court said that he was lying down.
It's my understanding he was reclined in the driver's seat, and they indicated he was...
As if the driver's seat were pushed back?
Yes.
Okay, so that could be wrong.
And 2 of the cases we cite in our brief, specifically State v. Barth out of Lake County in 2000, the court indicated that the mere fact that the vehicle was parked and that the driver was in the vehicle with his head tilted back and a cowboy hat over his face, that was not sufficient justification for a seizure on the opening of the door to that vehicle. So there is precedent indicating that what the Officer Gagliardi saw and did was simply contrary to the Fourth Amendment. I don't believe there's any question that he was seized by having a gun pointed at him and being removed from the vehicle. Another Ohio appellate case, similar factual background, was State v. Forrest. In And in that case, a warrantless police search of an occupied motor vehicle in a high-crime, so-called high-crime neighborhood, similar facts where the vehicle door was opened and the suspect removed from the vehicle where there was no observed crime. The 10th District Court of Appeals ruled in favor of the defendant with respect to the fact that there was no illegal activity to justify any sort of investigative stop by the officer and suppressed, reversed the denial of a motion to suppress in that incident.
Counsel, you have about 5 minutes remaining. It's up to you whether you want to save those for rebuttal or whether you want to proceed.
I'll proceed, Your Honor. The officer did not see any furtive movements. The fact that the vehicle was blocked in the driveway, he approached it with a gun drawn and opened the vehicle door before he saw any alleged evidence of a crime. We're asking that this court find that there was, in fact, a Fourth Amendment violation, that there was no exception which applied in this particular case insofar as there was no reasonable suspicion or probable cause to stop my client's vehicle or to seize my client in this particular case where it wasn't a traffic stop. Given the lack of reasonable suspicion or probable cause, none of the exceptions applied, and there was in fact, no warrant in this particular case, which would have justified the seizure and intrusion into my client's vehicle. The state has attempted to justify the action of this officer based on community caretaking function. However, the officer in this particular case did not point to any articulable facts justifying concern for safety of Mr. Cunningham, and if he was concerned that there was a health problem, it didn't make sense to pull a gun and approach the vehicle with a gun drawn. Furthermore, with respect to the confession subsequently obtained through custodial interrogation, the law is fairly clear that a confession obtained through interrogation after an illegal arrest should be excluded unless intervening events break the causal connection between the arrest and confession so that the confession was sufficiently an act of free will to purge the illegal arrest. That's Taylor v. Alabama, as well as Dunaway v. New York and Brown v. Illinois. In this particular case, Brown v. Illinois indicates that the fact Miranda warnings are given does not in and of itself attenuate the taint from the original unconstitutional arrest. And in this case, it's even worse because there was first obtained an unmirandized confession followed by Miranda warnings being given shortly thereafter. So we have an initial taint, then warnings afterwards. And that takes us into the second assignment of error. We argue that the trial court committed a reversible error by failing to grant the motion to suppress all the post-Miranda statements where the officer first questioned the defendant and obtained a constitutionally invalid confession before subsequently advising the defendant of his Miranda rights. In more recent years, we've seen the Supreme Court of both Ohio and the United States question the tactic of question first, then Mirandize. And the lead case is Missouri v. Seibert at the federal level and State v. Ferris at the state level. In this particular instance, Mr. Cunningham was questioned at gunpoint and gave incriminating statements without first being advised of his Miranda rights warnings. Under that inherently coercive situation, he indicated that he had in fact stolen the bong from across the street some 5 minutes earlier. The subsequent Miranda warnings do not erase that taint pursuant to Missouri v. Seibert and State v. Ferris, where the officer essentially obtained everything he needed in terms of a confession and then decided after that point to issue the Miranda warnings. Nor does the subsequent second Miranda warning later at the police station mitigate that. We would ask to reserve the balance of our time, and we would ask that this court reverse the decision of the trial court denying the motion to suppress and remand this case back for further proceedings with instructions to exclude the statements made by my client in violation of the Fifth Amendment and any items seized from the vehicle or observed by the officer in violation of the Fourth Amendment. Thank you.
again, Your Honors. May it please the Court, my name is Matthew Curran on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. As Appellant's counsel has rather ably laid out the issues, there are two assignments of error. The first pertains to the Terry stop, and the second pertains to statements obtained from the defendant after he was Mirandized. I'll take them in order, both chronologically and as the Appellant's counsel identifies them in brief. Beginning with the Terry stop, Appellant's counsel appears to make it sound today as if the officer really had no suspicion of criminal activity and just pulled in behind the vehicle because it didn't belong in the area. That's not true. The suppression hearing, the officer testified as to at least 6 or 7 unique facts which, in his opinion, led him to have reasonable suspicion that the suspect in the vehicle was involved in the robbery that he was immediately investigating a few minutes after its commission. Specifically, the officer testified that he was driving the area on patrol immediately after the robbery. There were no other vehicles really out a few minutes after midnight in this residential area of Brunswick. They were very close to the location of the recent robbery, within a few blocks, frankly, well, within a quarter mile. And as upon coming into a cul-de-sac, the officer turned around in the cul-de-sac and began driving, I think it's southbound, on the street. As he's doing so, a vehicle traveling northbound, immediately upon seeing the officer's vehicle, immediately turned into the first available driveway and stopped. Did not proceed further up the driveway. In fact, the rear of his vehicle was actually blocking the sidewalk close to the street. The officer continued driving a short distance, maintaining visual contact with the vehicle, and began running the license plate through his data system. He then noticed that no one got out of the car. No one was walking up the driveway as if they were going to the house. The lights on the house were not on as if the house was expecting company. Now, it's not completely unheard of for visitors after midnight at a residential address, but one would expect that there would at least be maybe lights outside, or the person who was going to the house, if that was actually their intended destination, would get out of the vehicle to actually make an approach to the house. None of those things happened. Instead, the person sat in the vehicle, did not make any attempts to get out. The license plate came back in the data system as belonging to Seth Cunningham in Medina, Ohio. The officer was in Brunswick. Clearly, this person did not live there and did not appear as if they were making an expected social call.
Or somebody turned in to look up directions, to text somebody, to do any number of things too.
Sure.
I pulled into people's driveways or pulled over quickly because I'm getting lost and I want to not keep going.
And I personally have missed a side street on an area with which I'm not familiar and made a quick turnaround. But the point is that I was not later found reclining in the seat as if to avoid being seen behind heavily tinted windows. And
but the officer can see that at that point, right?
Not yet, but he did.
Could he even ascertain if it was a male driving the pickup truck, if the windows were tinted?
That is not 100% clear from the record, Your Honor. It appears that the windows were heavily tinted. I think they were probably just within state guidelines for the amount of tint, but I probably could see that there was a person. Maybe he could make out that it was a male, but not much else beyond that.
And this is a pickup truck as well, where the officer's in a sedan?
I believe so.
So he'd have to be able to see up into the vehicle as well?
That was part of it. But I think the other part of it is that the vehicle made a sudden turn without the officer having much of a chance to verify, or to see into the vehicle. But that sudden turn was itself suspicious. And getting back to your point, Your Honor, Judge Carr, that the officer doesn't necessarily have to be able to explain away every possible innocent explanation. If the facts as he perceives them in his training and experience as a reasonable officer would perceive them, leads him to suspect that, hey, there's something maybe afoot here. I should investigate further. That's all that's required for the Terry stop. The officer just has to have reasonable, articulable suspicion. He doesn't have to confirm that there is in fact criminal activity before initiating the stop. He just has to have reasonable suspicion.
Was there some connection though between the robbery and the black pickup truck? Why would two? Apparently the man left the store on foot.
Correct. There was no nexus at the time he initiated the stop between the vehicle and the robbery. But he developed that connection based off of the unique, in his view, suspicious conduct that the vehicle engaged in close proximity to where the robbery had just occurred in a temporal nature. So the absence of really any other vehicles on the other surface streets, the absence of continuing on into the residential area, the officer's view, suspicious way that the vehicle turned in when he first saw the police car. Are those necessarily, in every situation, always indicative of guilt? No, not necessarily. Is it highly suspicious? Yes, and that's why the officer continued to investigate. Ran the information through the data system and found that the vehicle was registered to an address in Medina. He maintained visual contact with the vehicle to see if anyone got out. No one got out. These additional facts, beyond just the quick turn into the driveway, beyond the location of the vehicle in close proximity to where the robbery had just been committed, a quarter mile away, those additional facts are what led the officer to believe that, hey, maybe this could be my guy.
So is this a hunch that he's working on?
No, it's not a hunch in the Terry sense. He has articulable suspicion based on all of these events that this person might be connected to my aggravated robbery that I'm investigating, the person for whom I'm looking. Those are additional facts.
So the fact that he runs the license plate and it comes back in Brunswick.
To Medina.
To Medina.
In the city of Brunswick.
Well, I mean, that's in
5 miles, maybe.
Yeah.
After midnight, though. And there's no attempt by the person to get out of the vehicle. The lights at the residence aren't on. It does not appear to the officer to be a social call. If I'm going to a friend's house late at night, either I get out of the vehicle upon making my arrival, or there's lights on, the person's expecting me, or there's an event going on at the house. None of those things were
I'm in
happening.
the driveway, come on out now. I mean, he could be texting somebody in the house, I'm here, come on out. Or
Sure.
anything could have been happening, really.
Right. But again, the officer doesn't have to account for every possible innocent explanation, right? The people in Terry who were casing the jewelry store could have just been looking at a very expensive ring that they were thinking about buying in the future. But Officer McFadden didn't have to account for that possibility if he saw that these if he saw that these people outside the jewelry store were acting in a suspicious manner and it looked like they were casing the jewelry store. He could detain them.
But this person was sitting in a residential area.
Yes.
A house, it wasn't casing a jewelry store. And there's usually, when you use the term casing, usually, you obviously have the indicia of that activity.
Sure, but I've also seen burglary situations where, in fact, the first case this court had this morning was a situation where the defendant was using a ruse to see if anyone was home by saying, oh, I'm selling these pizza coupons. So it does not necessarily have to be very clear from their conduct that what they're doing is a crime. The officer can rely on their training experience, their evaluation of the situation in the setting of a reasonably prudent officer to view the facts and to draw a conclusion. The fact that he may turn out to be right or he may turn out to be incorrect does not alleviate his ability to detain a suspect to investigate further. That's the entire point of Terry.
Well, let's get to the opening of the passenger side door at gunpoint. What are the factors that that justify that, as opposed to, for example, knocking on the window and saying, excuse me, do you have business in this area?
Sure. And I think it's important to remember that the offense the officer is investigating is an aggravated robbery committed where the offender produced a weapon and pointed it at the clerk. So clearly the officer is aware when he's investigating this offense that, hey, there's a report that this person used a gun to commit a robbery at this store. So the officer is entitled to take reasonable measures to protect his own safety when he's conducting a Terry stop, right?
Well, sure, if he finds somebody who fits the description, but at this point, the only thing we know is that there's a male driving the truck, and the truck was not included in the dispatch.
No, but the male driving the truck the officer is patrolling, looking for the person who committed this robbery.
Well, we don't even know there's a male driving the truck at this point, because he can't even see in the truck to know if there's a male, even though the car's registered to a male, right?
Sure.
That's all we really know.
Well, but the officer also knows the officer approaches the car after all the other things have already happened, right? The truck pulls quickly into the first driveway. The person does not get out. As he approaches the vehicle, he sees the person reclined as if trying to avoid being seen.
How does he see that?
The windows are tinted, but they're not completely opaque. I mean, it may be difficult to discern particular things, but shapes are still clearly visible to the officer. I mean, I think maybe it's more translucent as opposed to transparent, but it's clearly
But
not.
it's also after midnight,
Sure.
and there's no lights on the house.
Correct. But he
I'm
could
troubled
still.
by this.
Well, but he has headlights that are making some reflection off of the street. I mean, it's not completely pitch black. The officer could see a little bit into the vehicle, but he couldn't see everything in the vehicle. If he could, we'd be arguing plain view of the ski mask and the camouflage jacket and the bong
She
found on the
wasn't even
seat.
wearing it. The camouflage jacket he wasn't even wearing at the time, right?
No, he was sitting on it.
The court said he was wearing it.
He was wearing it when he committed the offense. I think it's found, maybe he's sitting on it
In the car.
in the car, I think, is the officer's testimony. But regardless, when the officer opens the passenger door and has the suspect at gunpoint, the officer is effectuating the Terry stop, right? If you are an officer and you're conducting a Terry stop of a vehicle, which is a permissible way to conduct a Terry stop, you are entitled to take reasonable measures to protect yourself, especially when the offense you're investigating is an aggravated robbery committed at gunpoint. I mean, frankly, my question rhetorically to the court would be, what is the officer supposed to do? Not politely on the window in hope that the suspect doesn't have the gun in his hand ready to shoot the officer? That seems unreasonable. Clearly, the officer is entitled to protect himself in investigating this offense. His investigation is the Terry stop. He has suspicion, reasonable articulable suspicion, which he identifies at the suppression hearing, why he thought the person driving this vehicle was connected to the aggravated robbery. In effectuating that Terry stop, he drew down on the suspect who had just used a handgun to commit the aggravated robbery.
But it seems as if we're arguing from the point where we know that, after the fact, that he is the suspect.
And if that's the way it's coming across, that's not my intent, because I recognize...
I'm convinced of that, but I'm just saying that we have to look at the events as they're unfolding, not
Sure.
that we already know that this is the...
And I think maybe a useful analogy, I know it's not necessarily perfect, but a useful analogy here might be headlong flight upon seeing a police officer. Right? When the suspect turns quickly into the driveway and makes no effort to get out, and when the officer approaches the vehicle and sees the driver reclined back as to avoid being seen, at that point the officer has reasonable suspicion that this is the guy who committed the aggravated robbery. Without knowing later that he's going to find the bong that was stolen, the gun that was used, the ski mask, and the camouflage jacket, and without knowing that he'll later get statements, without knowing that, the officer still has reasonable suspicion that this is the guy who committed the aggravated robbery.
Well, it's interesting to me that at the time that the officer approached the truck, before he could see him reclining, he made the decision at that moment to block the truck in.
Sure.
So we have to step back.
Okay,
and
so
what
maybe
did he
we
know
lose-
at that point?
Maybe we lose the reclined nature of the suspect when he draws down. But even then, he still has no other cars on the road. And yes, the clerk gives a description that he fled on foot, but he left a store. Obviously, you can't drive into
Well,
the
it's in
store.
it's in a residential neighborhood. Didn't you just say that there's 3 cul-de-sacs right near the store, less than a quarter of a mile from the store?
Sure. So police could also reasonably suspect that even though the person left the store on foot, he would get into a vehicle to make a getaway. I mean, that's not unreasonable for the officer to suspect. So when he's driving around...
Maybe he's on foot.
But again, that's a possible innocent explanation that the officer doesn't have to completely reject in coming to a conclusion that this is potentially my person. The officer doesn't have to account for every possible innocent explanation. If he has reasonable suspicion that this is the person who recently committed or is about to commit a crime, he may detain that person to investigate further.
And you're out of time.
I appreciate it. Thank you very much.
And we proceed, counsel.
Just to follow up on a question that Judge Carl Moore made, I think Your Honor is absolutely correct when you're talking about the factors in this case that were known to the officer at the time. He knew that the vehicle was a half mile from the robbery scene, that it turned suddenly into a...
Was it a half mile or a quarter mile?
I'm sorry, a quarter mile from the robbery scene, turned suddenly into a driveway and parked, and that the vehicle was registered to a male. So the question is, do those factors alone give him reasonable suspicion or probable cause to seize someone at gunpoint? And our argument would be that that's not sufficient.
Is it reasonable suspicion or probable cause? He blocked 3 minutes. Does that elevate it to probable cause, or is it still reasonable suspicion?
Well, I think that if you look at it from the suspect's standpoint, have a gun pointed at you like this when you're in your vehicle leaning back, and to be ordered from the car by a police officer, that's the functional equivalent of an arrest. So the probable cause was in fact needed.
Well, I'm talking about from the time he blocked 3 minutes. I'm not talking about the...
The blocking in part, I think that would constitute, he would not be able to leave. And the officer testified that he could not leave. He would not have been free to leave the scene. So I think that at that point you have a seizure on that basis. I think that it's, frankly, the whole stop aspect, he was parked in a driveway and the officer was free to approach him, so that's not really the issue. The issue is the seizure and arrest and search of the vehicle with respect to the Fourth Amendment. And I don't think that there's any question that pointing a gun at someone and ordering them from the vehicle is at the very least a seizure, if not an arrest. And we argue that it was actually an arrest in this case. There really was no investigation per se. The officer pointed the gun at him, ordered him out of the vehicle, saw the items inside the vehicle which he was not aware of prior to opening the vehicle door. I think that we cite the case of State v. Hamilton in the brief for the proposition that the officer lacked probable cause to place Mr. Cunningham in custody and under arrest and make a warrantless entry to the pickup truck. State v. Hamilton was an 8th District case from 2011 in which the appellate court affirmed the granting of the motion to suppress, where the police officer had no probable cause to seize and place a defendant under arrest at gunpoint based on 2 minor traffic violations and alleged furtive movements inside the vehicle.
Well, and you're out of time, but this is a completely different case than 2 minor traffic. This is somebody that at the point that he thought he had reasonable suspicion, he's thinking that this may be the person that just committed an aggravated robbery with a gun.
But that was based on an inarticulable hunch, we would argue, because all he knows is this vehicle's in the vicinity.
I'm just trying to say, to compare it to misdemeanor traffic.
To follow the state's reasoning, you could have stopped any vehicle that made a sudden turn, any vehicle within a quarter-mile radius of this robbery scene. And that would be, there was no vehicle described. I think that's the important thing. There's no vehicle described in the report of the suspect. All we have is a male suspect.
I'm sorry, you're out of time. Thank you. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, and you also can check on the Supreme Court and the 9th District Court of the West Side. Thank you very much.
Thank you, Your Honor.
Thank you.